dismissal, do these actually apply to this employee? And then finally, make sure that there's no human rights issues or considerations that you should be looking at. So part of the first step is this jurisdictional issue, and this is an hour discussion in itself. But essentially, you need to take a look at the employee and decide, is this person going to be covered by their work, going to be covered by the federal legislation or the provincial legislation? And so sometimes it's an easy decision. If they're working in the administration for the nation, then it's almost certain that they're going to be covered by the federal legislation, the Canada Labour Code. Once you start branching out from there and you're looking at things like the schools, for example, I've done 5 or 6 decisions now dealing with schools where they've been found to be First Nation run schools where they've been found to be provincially regulated. And as you get farther out from there, then it's almost certainly provincially regulated. So your business entities, your corporations that you have running, essentially, if you're doing the same types of business that other provincially regulated entities are, it doesn't matter that the nation owns it or runs it, it's still going to be provincially regulated. So today we're just going to focus on those employees that are going to fall under that federal legislation. And so under the Canada Labour Code, the first part of it, just like the Employment Standards Act, there's minimums there with respect to severance. And so the notice obligations under the Canada Labour Code are fairly simple. After 3 months of employment, the employee is entitled to 2 weeks of notice. And this is the bare minimum. And so if someone's drafting an employment contract for an employee that's covered by federal legislation, that means you can't go below this minimum when you're setting out how much notice they're entitled to. And on top of that, the thing that's unique to the Canada Labour Code as compared to the Provincial Employment Standards Act is, instead of just having this escalating amount of notice, it has severance requirements. So after a year of being employed, there is a severance requirement that's a minimum of 5 days or 2 days per year of service. Of course, they have to make that a little bit complicated in the way they word it, but essentially what it means is for the first 3 years, you get 5 days. After 3 years, now you're at 6 days, and then it's 2 days per year after that. There's no limit on it. So one of the things that's important if you're doing an employment contract is you can't put a limit on the amount of severance that they're entitled to, because essentially it's unlimited. It's only limited by the number of years that they can actually work. And so normally we just phrase it as you get whatever severance you're entitled to under the Canada Labour Code plus X amount of notice. And that notice, the minimum amount of notice under the code kicks in after 3 months, and it never gets any more at this time. And so the reason why you still want to have an employment contract, just quickly, is because the common law obligations still apply. So you have this statutory regime. So the employee could go and file an unjust dismissal complaint. I'm going to talk about how that all goes. But let's say they miss the deadline, or let's say they get laid off and so they don't qualify for it to file an unjust dismissal complaint. They can always still go and file a wrongful dismissal claim in court. And the wrongful dismissal claim is that you failed to provide me with adequate advance notice of the termination. And so when someone says they're filing a wrongful dismissal claim in court, what's wrongful about what the employer did in that case is simply they didn't provide adequate advance notice of the termination. And so if the employer was able to say, we're having cutbacks effective 6 months from today, we're going to be letting you go because of these cutbacks, and 6 months is what's reasonable in the circumstances, there's no wrongful dismissal because you've actually given advance notice. But what normally happens is, because you have this ability under the common law to terminate without cause, quite often an employer will just say, today's your last day, we're going to pay you the amount that's of notice that you're entitled to. If the employee doesn't accept what's offered, they then go and file a wrongful dismissal claim, and the claim is that I wasn't given adequate notice of the termination. And so the argument really there is what's adequate, how much notice, and you're really only fighting over how much money do we have to pay to make this issue go away, because there is no right of reinstatement in court. And so they look at things when they're, as you're likely aware, age, availability of alternative employment, length of service, nature of employment. It's a pretty, really all you're fighting over is how much, and you're usually, because the courts don't have a precise formula, the range can be quite large sometimes, where, the plaintiff lawyer could send you a demand saying, we think the person's entitled to 12 months. And the other side could say, well, no, we think this one's only worth 6. And then you're going to settle it somewhere in between there. And it's going to take into account salary, benefits, bonuses, pension, stock options, all of those things in calculating that entitlement. Essentially, what would the person have made had you complied with your obligation to give them that reasonable notice, give them that amount of advance notice? And so, regardless of whether you're talking about a claim for unjust dismissal, a wrongful dismissal, or any other complaint, even in the provincial legislation, if the employer has just cause, the employer is not obligated to do anything. And so there's no unjust dismissal claim if the employer has just cause. There's no wrongful dismissal claim, and there's no claim for severance or notice under the Act, under the Employment Standards Act or the Canada Labour Code. But just cause is a very, very high standard, and quite often you have to go through the whole process of proving just cause in order to determine that you don't owe that money, or that the person doesn't have any rights to unjust dismissal. And so just cause, as you probably know, you can look at things such as dishonesty. The Supreme Court of Canada has essentially said you have to take a contextual approach in what looks at just cause. So if the person's been there for a long time, and it's very, it may be something quite minor or trivial, then dishonesty isn't always going to be just cause. Even theft is one of the ones that usually is just cause, but there are circumstances where they have found, small amount of theft wasn't just cause, didn't completely undermine the employment relationship. Intoxication at work, sexual harassment, misrepresentation, willful disobedience, conflicts of interest, interfering off-duty behavior. We could talk about all these again. We have a very short amount of time, but essentially, if you have that just cause, then that's the one you have to look at. If we're looking at someone who's covered by the Canada Labour Code and the unjust dismissal provisions, do we want to allege just cause? And essentially, if they fall within all of the parameters of that case, that may be one of your only options to get rid of the person, is to allege just cause. If it's not a layoff, they have been there more than a year, and all the different things that we're going to talk about. If they fall within that category, now we have to look, does this particular case warrant alleging just cause for the termination? Now, poor performance can be just cause, but again, because that threshold is so high, it's something where you really need to build a case that you do in fact have just cause. So you have to bring the poor performance to the employee's attention, set targets, reasonable, achievable targets. Here's what our expectations are, offer them support. They still fail to improve, you give them another warning depending on how long they've been there, and then you let them go. If you're looking at a 15-year employee that's never had an issue and now all of a sudden there's a problem, that process is going to take some time. And if they are covered by the unjust dismissal provisions, you do want to make sure you get it right. Otherwise, you can end up with the employee back, which is what I'll be talking about a little bit more. And so you hear people throw the words around unjust dismissal, wrongful dismissal kind of interchangeably, and they're actually quite different. So an unjust dismissal is a very specific type of claim under the Canada Labour Code, falls under Part 3. A wrongful dismissal is a claim in court that you simply haven't been given enough notice of your termination. And it can be a valid dismissal, like a layoff or something else. They can still file a wrongful dismissal. An unjust dismissal, it has to fall specifically within the categories as set out in the Canada Labour Code. So it's very important that you know what kind of claims fall within the unjust dismissal claims. And the reason why that's so important is because the remedies under the Canada Labour Code are so broad and so remedial that and one of the most important ones is that you could end up with this employee back in your workplace if you did it wrong. And so you can imagine if you terminate someone because they're really causing problems in the workplace, you really don't want them around, you let them go and they file an unjust dismissal claim and an adjudicator puts them back with full back pay, that's going to be a worst case scenario for you as an employer. It's going to hurt morale within the workplace if it was someone who had been causing problems there. And now you're probably going to have a even more difficult employee to deal with because they're going to feel invincible and like they can, do what they want, and that there's not going to be any repercussions. So the changes to the Canada Labor Code, as you're probably aware, there's been pretty significant changes, and Siobhan was going to talk about breaking down a lot of the detail of what those changes are. As far as the unjust dismissal provisions, the changes are more procedural than anything else. So now when they talk about the head, which is the head of the CIRB, basically may request, and they could always do this, if you terminate someone and the person wants to know if the termination falls within the unjust dismissal provisions, they can simply file the complaint and ask that the head make request. And if you get a request saying, we want to know the reasons for the termination, you have to provide a response setting out your reasons. And if your reason, and this is an important stage because you're basically stuck with those reasons, and so you want to make sure that you do it right. And normally, if you've done a termination letter that sets out in clear detail what your reasons are, the head will simply say, well, these are the reasons, this satisfies your obligation, you don't have to do anything more. If you've just done a simple, your employment termination letter without giving any reasons, then this is your opportunity to try and figure out, okay, well, what is our defense to this unjust dismissal claim? Are we going to allege just cause? Are we going to say this is a reorganization or a layoff? We need to make that clear in that letter when they ask for those reasons. The other new part now is once a labor program inspector is appointed, they then ask the employer, they give the employer an opportunity to reply to the claim in writing. And that reply in writing, they could use that reply and make a decision based on the claim, just based on the written submissions of both parties, because there'll be a reply and then a final response by the plaintiff. If you don't put enough information in that written submission, they can make a decision just based on that. Once they've got those submissions, they then take that opportunity to see, is this something we can settle? Can we do a mediation? Can we settle it? Are the parties interested? If they are, then there's a free mediation process offered. If it's still not resolved at that point, what they used to do is they would send it to outside adjudicators, which were simply arbitrators, mediators out in the community. They would take it on, and then they would do the hearing. Now the Canada Industrial Relations Board has taken jurisdiction over those. If they get overwhelmed, they still may contract that out to those same adjudicators. But for now, I just did a case 2 weeks ago, and it was with one of the vice chairs from the board, sitting on his own. He was adjudicating the unjust dismissal claim. And it was an oral hearing it was a Zoom hearing, and we had provided written submissions in advance based on some preliminary issues. But the main part of the case, the unjust dismissal claim, was all done by oral hearing. And then the next step is, once that hearing has been done, a written public decision is going to be made by the CIRB or its designate. And so those decisions are all going to be public and available and searchable. And so you want to make sure that you don't end up in a position where you've got a public decision against the nation saying that you've acted improperly or had to reinstate one of these employees. And so the key for the unjust dismissal provisions is just really understanding when they apply. And so the first thing to look at is this person actually an employee? This was actually one of the issues in the case that I was working on. And so if you've hired the person as a contractor, and this is quite often where you hire people in contractor positions, the person has to actually be a true independent contractor. And so the way the code is written, they actually says any person may file an unjust dismissal complaint, and then goes on to say, talk about that employment relationship. And so essentially the test for employee is quite broad. And so if the person, even if they're calling themselves as a contractor, is actually just doing regular day-to-day employment relationship, employment duties, and doesn't have their own business, and it's not something that could just be, it's part of the core of what you do as a nation. So let's say you bring someone and you call them the bookkeeper, a contractor, but they're working for you 40 hours a week, and they're only doing work for you, and you're just paying them as a contractor. They're likely going to be found to be an employee, even if you have a separate contract for services. So you have to be very careful. Just because someone's called a contractor doesn't mean necessarily that they are. Now, if you're going to remember anything from this presentation, I would say that this first bullet point here is really key. Essentially, an employee cannot file an unjust dismissal complaint unless they've worked for the organization for 12 months. And so what that means in practice is you've got 12 months essentially to assess whether this is someone you want as an employee indefinitely going forward. Because after that 12-month period, essentially the only way you can lawfully get rid of, terminate that employee if they're not performing is just cause, which we've talked about as a really high standard, or if it's a bona fide layoff or reorganization that you're doing. If they just turn out to be a really painful, difficult employee, but if they're not giving you just cause for termination, you're probably going to be stuck with them. And so if you're already experiencing problems, quite often I have clients, they get kind of focused on, well, the probationary period is 3 months, or the probationary period is 6 months, or whatever it is. Don't worry about the probationary period. Don't worry about any of that stuff. If you're getting up to 10, 11 months and this employee has been nothing but difficult and problems for you within the organization, you want to think long and hard at that point. Okay, do we want to just do a without cause termination, pay them some severance, and send them on their way? Or do we want to let them roll over that 12-month mark where we're now no longer going to be able to do a without cause termination and just pay them some severance if it's not working out? And so that 12-month window is your window for assessing, do I want this employee to be a forever employee essentially for the nation, or do we want to look at maybe transitioning this person out now while we still can? The other requirement, obviously not covered by a collective agreement, but that doesn't really matter, because if they were covered by a collective agreement, then they would have basically the same protections as the unjust dismissal provisions. And it's determined at the date of the dismissal. So even if you go that 11 months and 29 days and you decide, okay, today is going to be your last day, they can't then go file a complaint. And so you got to make sure, one of the things as a HR person is you have like a diary system. You'll want to bring forward that, have a warning maybe at the 11th month point. Oh, have we done an assessment? Do we want this person around? Is this someone we want to be a forever employee of our organization? Another requirement, and this is one that we end up arguing over quite a bit, is that the employee, if the employee is a manager, then they can't file a complaint under the code. Unfortunately, there's no precise definition of manager, and so we have to look at how they've interpreted it in the past. And essentially, they look at what is the work this person actually performs. Even if their job description calls them a manager, says they're a manager, says they can do all these things that means they're a manager, what they're going to look at is what do they actually do? Have they actually done hiring, firing? Do they actually have the ultimate say over decisions that get made? Are they employed in a significant senior manager position where the vast majority of their work is administrative in nature? Or are they just doing a job like anyone else, where they're just, we call them a manager, but they're they're the office manager, but they're the only person who works in the office, and they just basically do the role of an administrative person. Or even there's been even cases where the most senior person in in a nation has been found to be not a manager because the council was seen to be actually completely running the show and getting involved in the day-to-day, and had taken away so much authority from that administrator that their job was essentially a non-managerial position at the end of the day. So it's very important that you consider, just because the person has the title of manager, are they actually a manager? If they are, then your only concern is, well, if we're going to let them go, how much are we going to owe them in severance? And that's where your employment contract comes in. And then no other redress, should they be filing on a Canadian Human Rights Act? This doesn't really actually provide you as an organization with much protection. It just means that they should be going to a different forum. And then the one thing that is unique to the Canada Labor Code, and is quite a small window, is the limitation for filing a complaint is only 90 days, which is actually quite a short period. Now, previously, quite often when I would get these claims, we would have back and forth negotiations, and a lot of plaintiff counsel weren't aware of this 90-day time limit, and it would pass. And once that's passed, it's very difficult for them to try and get them to extend that provision. They almost never do. And lawyers' incompetence isn't a good reason to extend that provision. And so, but now the lawyers that are doing this type of work have become more familiar. This is, I'm getting far more claims for unjust dismissal now, and the plaintiff lawyers that are out there are becoming far more familiar with the process and the provisions. And so it's pretty rare that they're missing this time limit anymore. But it is important to know, if you've let someone go more than 90 days ago and you haven't heard from them, and you haven't heard a complaint, then you can breathe a sigh of relief. You're probably not going to get an unjust dismissal complaint. Now, some of the other requirements of the unjust dismissal provisions are that it must actually be a dismissal. So the non-renewal of a fixed term contract. So if you have a fixed term contract and it's just simply not renewed, then that's not going to be a dismissal, as long as it's a true fixed term contract. And so quite often employers will use to go along with their funding. If there's a risk that they might lose their funding, they'll use a fixed term contract that coincides with that funding arrangement in place. And it makes it clear that if that funding is renewed, then we'll renegotiate at that time. And so if that just were to end, then there's no chance of it. Even if they've gone over that 12-month period, they're not going to get they're not going to be able to file an unjust dismissal complaint. So discontinuance of a function or layoff due to lack of work. So these are essentially that reorganization that I'm talking about. Now, what they'll want to look at is, did you just discontinue this function because you don't like this employee, or is this a bona fide restructuring? And so if it's actually, oh, we're going to change the way we're doing things and we're eliminating these positions, or we've lost funding and so we're laying people off, that's all going to be legitimate reasons for letting someone go, and they won't be able to file an unjust dismissal complaint. As I said before, they can still file the wrongful dismissal complaint in court, but if you have an employment contract, then you'll at least be able to limit how much you owe at that point. And then obviously if the person resigns and it's a true resignation, it's found to be a true resignation, then they can't file a complaint. One of the difficult things in dealing with the unjust dismissal provisions is if you terminate someone and you give them some severance, immediately, and they just sign a release while they're sitting there, and then they realize, oh, I could have filed an unjust dismissal complaint, and they're still within that 90-day time limit. The release isn't necessarily going to prevent them from filing the complaint. You can't contract out of the unjust dismissal provisions, and so you can argue that there was a binding settlement, but the board could always just say, no, we're going to put that aside, and we're going to hear the complaint, and we're going to determine whether or not reinstatement is appropriate in the circumstances. And so the Supreme Court of Canada case that I was talking about that kind of changed this with the effectiveness of contracts is the Wilson and Atomic Energy. It wasn't really a change, but it just confirmed that just because you get a contract that says, here's what you get if we let you go without cause, and then you give them that doesn't mean they can't then still go file an unjust dismissal complaint. You can't contract out of their ability to file the complaint. And so even if you've paid them in accordance with their contract and terminated them for cause, There was some question before, but this case essentially said, no, that's no longer the case. And so again, when you're looking at, is the dismissal unjust under the code? They're going to want to see that you've used progressive discipline if it's appropriate in the circumstances. Your policy and procedure manual is going to be very, very key. They want to look at, did you actually follow your own policies and procedures? If you have, a bunch of steps that you're supposed to go through in order to terminate someone and you didn't follow those steps, it's almost certainly going to be an unjust dismissal, even if had you followed those steps, it would have been upheld. And so it's important, if you're looking at dismissing someone, that you go to your policy manual, see what it says about termination, see what it says about discipline. And the adjudicator is going to look at all the circumstances. And then if they find that it's unjust, they may order a remedy. That remedy can include compensation. So quite often they'll order back pay right to the date of the hearing. They also order damages for things that they would never order damages for in court, like hurt feelings, pay for any losses that they may have sustained, having to move or other things like that. They can make claims for that if they think it's fair. Basically, the test is any other thing that is equitable, which a lot of adjudicators have taken quite far. Asking to provide reference letters, which the court would never do, those kind of things, written apologies. Those don't happen in court, but they can happen in adjudication. So this is not an unjust dismissal claim. If the person's successful, is not somewhere you want to be as an employer. And so even though the case, basically you can't contract out of these types of claims, you still want to have employment contracts, because those employment contracts can be used to limit any claims. If you are able to get out from under the unjust dismissal complaint, they still have that wrongful dismissal that they can file. And so you want to make sure you have an employment contract that limits the amount of notice and severance that you have to provide the person to what you think is reasonable as an organization. And so those written contracts will give you some certainty. It's going to cut down on the disputes and give you more reduced predictable costs when you do have to do downsizing, you do have to make legitimate changes, and it's going to give you added protection. And so really the biggest key takeaway is just to understand when the unjust dismissal provisions are going to apply to a decision if you're going to let someone go. Is there a risk this person could file an unjust dismissal complaint? And just go through those steps. Again, one of the key ones is that 12-month window. In that first 12 months, you want to make sure that this person is a good fit for your organization and it's someone that we want long-term an employee. If they're not, now's the time to act. Don't wait till they roll over past that 1 year. And so I see Siobhan is in here. Is your microphone working now, Siobhan?
Hi, everyone. I had to call in because Zoom doesn't like me. But if you want, I can do a super quick kind of presentation on my part, and then we can leave a little bit of time for questions, because I don't think we have too much longer left. Is that right?
Yeah, I think we have about 15 minutes or 20 minutes left.
Okay. What I'll do then, everyone, I won't be able to present because I'm over the phone, but you will have a copy of the PowerPoint presentation, and you'll also have a copy of links that were provided to this that you can either bring up now if you'd like, or you can take a look at them later. There's a lot of good information in there. Originally, the presentation was going to be just about 20 minutes. I'm basically just going to skim through it really quick so that we can leave some time for questions. I do want to say, though, before I jump in, I'm going to be just talking about really quickly some parts about Part 3 of the Canada Labour Code. Part 3 is huge. I think the last time I did a presentation on just some parts of it, it was almost 4 hours if you included questions. So what I will say as I go through this, if you have any desire, or you would like to request something like your own seminar in your own workplace, or maybe just a counseling session, or even just to have some packages sent to you with just some information, that's something that we can easily set up. My email address is in the PowerPoint presentation. You can reach out to me directly and we can set something up, or I can put you in touch with another inspector, and then we can kind of discuss and build something up to meet your needs. So please keep that in mind. And as I go into the Canada Labour Code, just remember this only applies to federally regulated workplaces. I think in the previous session, Melissa and I think another participant had quickly touched on jurisdiction. It can get really complex really quickly. The only way I could give you a certain answer on if you are or are not federally regulated would be if you filed a complaint and then rendered a decision. That's obviously not ideal, so we recommend you can either call our 1-800 number and they can give you some general guidance, or you could reach out to legal counsel and they might be able to help you as well. So I'll jump right into it. The first part of the presentation is going to be on record keeping. And what I'll say to keep it really quick is keep more than you think you'll need for longer than you think you'll need it for. If you take nothing else from the presentations today, please let it be record keeping. I cannot emphasize how important record keeping is. And I think that's something that Scott was touching on as well. There's a big long list of things that are required under the Canada Labour Code. Those are listed in Regulation 24, and I provided a link to that as well that you can check out if you'd like. The important thing to keep in mind is that the records need to be kept for at least 36 months. So that's 3 years. I will touch base specifically on pay statements though. For those, you do want to ensure that you include some basic information. So that includes the period that the payment was made for, the date of the payment, how many hours are included in that payment. So if they work 40 hours a week and you pay them biweekly, it would be 80 hours would be paid out, the rate of wages, the details of permitted deductions, and the actual sum being received by the employee. To kind of go back to deductions, that means things like CPP, EI, income tax, anything like that. Those should be broken down on the pay statement. And I would also say that if you're paying anything like overtime, general holiday pay, or even vacation pay, something I see with employers that kind of gets them into trouble is they don't break that down on the pay stub, and that can lead to a lot of heartache, for lack of a better way to put it. So make sure that you have those breakdowns on there so that it's clear to you, it's clear to your employee, and that if there is a disagreement and there's a complaint, that when it comes into an inspector, it's really easy for them to be like, oh, okay, this amount was paid on this day. That's something that you want to keep on mind. I had a section on here in regards to termination pay. I think Scott did a pretty good job going into termination and unjust dismissal. What I will say though, is to kind of keep in mind is that for us under the Canada Labour Code, or at least the Labour Program, if a complaint comes in, there's two different kinds of complaints that we deal with. There's a monetary complaint for severance and termination pay, and then there's an unjust dismissal complaint. And they're two very, very different processes. If you do get one of these complaints, the inspector will walk you through what's needed and the differences. But the big difference is on a monetary complaint, the inspector has decision-making power. So we'll collect evidence from both parties and make a decision. Whereas in an unjust dismissal complaint, we have almost no decision-making power. All we can really do is mediate the dispute between the two parties. And if no resolution, is achieved, then the employee or the complainant can request that it be referred to an adjudicator. What I will say just before I touch on termination and severance pay, because it's been in the news so much, are layoffs. The reason I want to touch on those is because what I keep seeing is that layoffs are being used interchangeably for termination, and they're two very different things. A layoff is when the employer intends to recall that employee, and a termination is when that's it, the employment relationship is done. The regulations and the code don't touch too much on layoffs in terms of the return to work afterwards. If you have had layoffs due to COVID-19, what I will say though is to keep in mind layoffs still count as that employee's continuity of employment. So for things like severance and termination pay, let's say someone worked there for 3 months, was laid off for 2, and then worked another few months. That layoff period still counts as if they were working there. So if you're looking at terminating that employee before that 12 months is up, remember their layoff period counts towards that 12 months. Termination and severance pay are similar but different. Just to kind of recap, I think Scott might have touched base on this. Termination pay is either 2 weeks pay or 2 weeks notice. And an employee to be able to be eligible for that has to have at least 3 months employment. Whereas severance pay, someone has to have worked there for 12 months, so a full year. And it's the greater of either 2 days pay per year or 5 days wages. So if someone worked there for 2 years, they would be entitled to the 5 because 5 is greater than the 2 per year. But if they worked there, let's say for 10 years, then they would be entitled to 20 days severance pay in addition to their termination pay. Obviously, if someone is terminated with cause, those amounts don't have to be paid. But this goes back to record keeping. If you've been rendering discipline, whether it's verbal, written, final warning, suspensions, whatever, you want to keep those records because if they file a complaint, you can, you could tell an inspector, oh, well, we did this, we did that. If it's not written down, we don't have that proof, and so we can't really consider it more often than not. So record keeping is super, super important when it comes to discipline and leading up to termination. In terms of actual unjust dismissal complaints, this was covered by Scott as well, but an employee has to work there for 12 months. Their complaint has to be filed within 90 days. It does say in the code that the employee must not be a manager, and there does have to be an employment relationship. The one thing you want to keep in mind is that often the person that's receiving that complaint with the labor program, we can't even make that decision on if someone was a manager or if there was that employment relationship. We basically have to allow the complaint and try and mediate it. And then if no resolution is reached, then it would go off to the adjudicator with the CIRB, so the Industrial Relations Board, and they would be the ones that would make that decision. The inspector who receives it wouldn't really have a choice. We would just have to accept it. What I will say though, before I switch gears again, is that whether it's an unjust dismissal complaint or a termination severance pay complaint, it also applies to constructive dismissal. So if someone says that they were forced to quit, the only difference here would be where you, the employer, are terminating an employee, the onus is on you to prove that you had cause to dismiss them. But where we have constructive dismissal complaints, the onus changes and it's on the employee to prove that they were basically forced to quit. So that's the big difference there. The next thing I want to touch base on was leave related to COVID-19. On that sheet of links that were provided to you, there's a really great link on there for information in regards to COVID-19. I really, really strongly suggest you check it out. There's information for labor standards, health and safety, as well as some other links on there for things like mental health. But there are 2 different types of leave that are accessible in regards to COVID-19. These are temporary measures to deal with the pandemic. One is for 4 weeks, one is for 42. The big thing I want to emphasize for these leaves is that neither of them are paid. It's just job security. And the other thing I want to touch base on in regards to COVID-19, again, this is something that I've seen in the news a lot, and that's leave specifically for vaccination. Some provinces might have this in their labor standards legislation, but it's not in the Canada Labor Code. There's no specific designated leave for vaccination. An employee might be able to access different kinds of leave, but it's not in the code, so just keep that in mind. So I'm just at the very end of this really quick presentation. There's just a couple of things I want to touch base on. Were just a couple of the bunch of the new leave provisions that have come out. It's not so new anymore. They came out in 2019. The first is personal leave. I mentioned this because we've been seeing a lot of it coming in. And the thing that's important here is that someone is able to access that leave on the first day, but after 3 months employment, 3 of the 5 days that they're entitled to in a calendar year will become paid leave. And then the other type of leave that's also come out that may be of interest to you is there's a specific leave for traditional Indigenous practices. An employee is able to tap into this leave with at least 3 months of continuous employment, and they're given 5 days per calendar year for things like hunting, fishing, harvesting, or gathering. The thing here is that leave for traditional Indigenous practices is not paid. So under the code, it doesn't require payment. However, if you as an employer would like to, you can definitely go ahead. And the last thing I'll touch base on here today is general holiday pay. This is brand new, and there were rumblings about it for quite a long time, whereas previously there were 9 general holidays. Now there's a 10th, and that's the National Day for Truth and Reconciliation. This will be every year on September 30th. So this September 30th will be the first year that this is official. And this would be like any other general holiday. So if someone works that day, they would be entitled to time and a half, or an employee should be granted the day off. The day specifically is to give employees in the federally regulated sector the opportunity to participate in educational and commemorative activities related to Indian residential schools and reconciliation. And like I said, this September 30th will be the first year that this is officially a general holiday. So it's really great to see that. So that was my very rushed presentation. Like I said, if you're looking for more information, or if you want to set up a seminar with you or a counseling session or anything like that, please reach out to me, and I'm happy to help. Otherwise, I will kind of let the floor be open for questions, and hopefully we have enough time to answer some of those.
Can I ask a question?
Yep.
I have an employee who's on sick time. She has a doctor's note now, and for the next 2 weeks to 4 weeks, and then she's asking for vacation time off. What do I do there? She wants a vacation day.
So she wants to take a vacation following her sick leave?
Yeah, no, just during her sick leave. Her sick leave is between 2 weeks to 4 weeks, and the sick day she wants to take is on the June 28th, today.
Okay, so that's going to go back to your policies as to whether or not you have the discretion to determine when the person takes their vacation time or or collects their vacation pay. So the employee has a right to take a certain amount of vacation and per year, but you also have the discretion generally, unless you've taken that away in your policy, to determine when that is and when that's convenient. And so if it's a pre-booked vacation, then you wouldn't be able to take it away if she was planning on going just because she was sick. But if she's off sick and she just decides, no, I want to take my vacation now, and that's not convenient for you, you don't want to allow it, then you would have the discretion to make that decision, as long as your policy manual doesn't prevent you from doing that. And so quite often employers will allow that, though, so that the person has access to some pay while they're off sick, so that they're not suffering financially while they're away. They're allowed to use up their vacation, but that's at your discretion.
All right, thank you.
Yep. Any other questions about Part 3 of the Canada Labor Code, unjust dismissal, or any other of the issues that we're talking about?